just found out that the book is available for pre-order on Amazon. So big congratulations to Eric on
Eric discovered that while preparing for this.
Yes, but still very exciting. And actually, Eric is this is Eric's second book on habeas. The first one is called Habeas Corpus: Rethinking the Great Writ of Liberty. And the forthcoming book is what this talk is going to be based on, Making Habeas Work, a Legal History. And we are also very fortunate, Eric is going to be delivering the university-wide Distinguished Faculty Lecture fall 2017, which is November 15th. So hopefully we can all make it to that as well. And demonstrating the depth of his expertise, that's on an entirely different topic. And so that, I believe, is on the death penalty and death penalty cases. And so Eric has several areas of real expertise. Eric also graciously spoke at our Constitution Day panel on whether a sitting president could be indicted. And so we are quite fortunate to have Eric with us. And so, without further ado, I have some extra copies of I see everybody has one? No. Yeah, and actually that was the first 3 chapters. Eric also had sent in the original email, this is the introduction to the overall book, which gives a really nice overview if anyone wants to take a look at that, which I had sent in one of the emails but didn't attach it yesterday. So here's some extra.
May I have that?
Sure, please. Then anyone else
I think it
wants.
was in the email.
Yeah, okay.
I guess, I've said to the Gordons that they remember everything and learn nothing. In my case, I remember nothing and learn nothing. And when I did speak at that Constitution Day event, I said I should learn from Mark Twain. And after introductions like that, stay silent and be thought a fool rather than over your mouth and move all doubt. So here I am giving another one. And I would apologize, for not using PowerPoints and telling you you got to follow me on paper. But you're all lucky. I could have handed out some writs of habeas corpus. When I did this in New Hampshire, I handed out stuff like this to the audience, and they haven't invited me back. All right, so the subject for the day is what is meant by habeas corpus and why does definition matter? And as you all know, at the simplest level, habeas corpus is an order to the jailer that says produce the body along with an explanation of why you are holding the body. Right? Writ of habeas corpus cum causa, with cause. Okay. It doesn't say, and if I, the judge, don't like the explanation, I'm going to order him released. That's just implicit. And by its being implicit, a latent ambiguity arises. Because at its core, the essence of the writ is making the jailer show up and show a neutral authority the legal and factual entitlement to hold the prisoner. And the prisoner may then win or lose on the merits, which of course is important for the prisoner. But the important part to the rule of law is that there is independent scrutiny of the justification. And what began to happen fairly early on, and still persists to this day, is a terminological confusion between prisoner was granted a writ of habeas corpus, meaning the judge conducted an independent inquiry into his detention, and prisoner was granted a writ of habeas corpus, meaning judge ordered prisoner released. And the government benefited from that confusion in the Guantanamo cases. There are a number of old cases in which the prisoners were aliens who posed a greater or lesser degree of threat to England, and in which judges reviewed the cases and concluded habeas corpus denied, meaning order of release denied. And the government cited those cases to the courts, saying what they mean is no judicial review of the detention. And I don't attribute malice to the government. The realities of practice at common law were very different from the law as you might see it in one of the few published cases that a lawyer, even a totally conscientious lawyer sitting in the library of a major university or Library of Congress anyway, would find by researching the printed cases. And all I can say is, thank God for the historians. And in particular, for one historian of English habeas corpus in the history department of the University of Virginia, named Paul Halliday, who quite independently and long before Guantanamo or anything like that, had been working on his tenure book in the English archives for 9 years. You think we have a tenure track? You think our people get worried about whether they're going to get tenure. He spent 9 years publishing nothing. He spent them in the archives in England, and pieced together the complete files on over 5,000 prisoners. There are actually 11,000 files, 11,000 that could be done. He couldn't find himself and put together. And the way you do that is, it's a map work that I did on a smaller scale in New Hampshire. The pieces of paper come in random, sort of random times, random orders, are filed in random ways. And you piece together the file by discovering over here that this is actually relates to this case over here, except, and he's got and I can show you, I've got his book, he's got a long discussion of where they all are. But when he does it, they're in several languages. They're in Latin, they're in French, they're in English. And there are abbreviations annotated at the side. It's a discharged or proceeding under statute or whatever, which it does in a short abbreviation in one of those languages. So he puts together those pieces of paper sufficient to get complete files on 5,000 prisoners. And it just so happened that he had completed a usable manuscript, wasn't published, but a ready-to-go manuscript just at the time the litigators needed this. And let me give you an example, elaborating on the middle of page 1 of the handout. The rule, which you can find in any published case, is that the prisoner may not controvert the return. That is, if the jailer puts in a written document saying, I'm holding him because he shot 5 arrows towards the king and therefore is to be tried for high treason, according to the rule against controverting the return, the prisoner is limited to the question of whether, assuming as a fact that he shot 5 arrows towards the king, this is a legal basis to try him for high treason. The reality is completely different, as I summarize at the bottom of page 1 and the top of page 2. If the jailer claimed to be holding a prisoner on that basis, the judges would use any one of a variety of legal technicalities to demand factual proof that there was some good basis to believe that the prisoner had shot those 5 arrows. And what they would do by one means or another, and the technical ways of avoiding controverting the return to the writ are all in there. But what they would do by one means or another was to get as close to firsthand knowledge of the facts as they could. If there were available witnesses, they would call them in. If they had to take proffers from counsel, they would do that. If they had to take affidavits, they would do that. They were certainly less good, but better than believing whatever the jailer says. And then the judges would focus closely on what the jailer had shown and critically failed to show before getting to any possibly complicated legal question. So they might listen to all the evidence and conclude, well, there is some basis to believe that the prisoner was out there practicing target shooting at the time that some his arrows flew in the direction of the king, but there's no basis to believe he was shooting at the king. Then they would dismiss the return for legal insufficiency because it failed to say he was shooting at the king. It said he shot towards the king. And by that means, the prisoner had never controverted the return, but he had been entitled to put on his evidence, and if the government hadn't shown that it had a solid basis for the detention, the prisoner went home. And then indeed you would get an order that said writ of habeas corpus granted. But suppose they concluded the other way on the facts, that it would seem that this archer was aiming at the king. Then they would say writ of habeas corpus denied. But as I say at the top of page 3, the prisoner had in fact gotten habeas without the writ. He had gotten a full examination into the circumstances, although not released. And if you read a printed case that only contains the return and the disposition, habeas denied, you wouldn't know all that. And so you might conclude, as a matter of law, that people accused of high treason were not entitled to habeas corpus, which is essentially how the government misread most of the cases they relied on in Guantanamo cases. And so, despite our best efforts, that's more or less what happened in the Fourth Circuit in the Hamdi case at the middle of page 3. Hamdi was held as an enemy combatant in Virginia. He got to Virginia because they had him at Guantanamo. He was living in Saudi Arabia. They had him at Guantanamo. When they discovered that he was an American citizen, having been born in Louisiana, they promptly moved him to the United States in order to keep Guantanamo a habeas-free zone. So, in response to his writ of habeas corpus in Virginia, the government put in an affidavit from a mid-level bureaucrat by the name of Mobbs in the Defense Department, who said in his declaration, "I've read all the reports from the field, and they say that Hamdi was carrying a rifle in Afghanistan in the presence of U.S. troops." And the district judge, who was a conservative Republican and a former military man, looked at that and observed its motionless and said to the U.S. attorney, "Let me ask you a couple of questions. Who is this guy Mobbs? What does he know and how does he know it?" And when he heard the answers, which were, well, Mobbs is a guy that's sitting over there in the Pentagon, and he's gotten a lot of reports from Afghanistan, the judge sensibly said, "Okay, you send me the underlying documents to his declaration and any other eyewitness reports that are sitting around in the Pentagon, and I'll read all that, and then I may want to hear from Mr. Hamdi." Well, the outraged government wasn't having any of that, and forthwith took an appeal to the Fourth Circuit, and which reversed in an opinion that criticized the district judge for approaching the Mobb declaration by examining it line by line, and for suggesting that the writ of habeas corpus might require Hamdi to be produced in court. Instead, says the Fourth Circuit, the government only needs to present factual assertions that would, if accurate, provide a legally valid basis for Hamdi's detention. Jen, Matt, take copies of this because okay, so in other words, no controverting the return, based on the misreading of some of those old English cases, meaning no hearing as opposed to no release. And I might add, completely ignoring a series of American cases at page 2 and all the footnotes, which get more cases, which are ones that I dug up from my last book, in which people in military custody got full evidentiary hearings. Fortunately, we got all this seriously together for briefing in the Supreme Court, which made it quite clear on oral argument that it was having none of this effort to truncate judicial inquiry. Led by Justice O'Connor, they gave Paul Clement and his sophisticated legal argument a very hard time. Justice O'Connor said to Paul Clement, who was Solicitor General at the time, why wouldn't you just give the district judge the evidence? And he said, well, you don't have to do that in the President of the United States, and the President of the United States wasn't. They were really moved by the federal public defender of the Eastern District of Virginia, who came absolutely back on rebuttal and said with some intensity, well, I'm just a trial lawyer. I don't believe any of that, but that's what he said. I'm just a trial lawyer. But I never thought I would hear it said in an American courtroom that an American judge can't inquire into the detention of an American citizen. And take that Paul Clement and stuff it. I don't work here. And the Supreme Court reversed and sent it back to the district judge, who scheduled a hearing for a week later. So on October 5th, he scheduled a hearing for October 12th. And he told the government, you show up on October 12th with Mr. Hamdi and with the evidence that supports holding. And the day before that hearing was supposed to happen, on Sunday, October 11th, they sent Hamdi home to Saudi Arabia. All right. So no one ever ordered his release, but he sure got habeas corpus, right? The right to a full examination of the circumstances of the imprisonment. And so building on that functional definition of what habeas corpus is, we turn to chapter 2 in pursuit of this idea that what matters is the substance and not the name. And here we have a bunch of fun cases from the New Hampshire Archives, which I can spin out to a greater or lesser length, including Dan Greenwood's favorite case, in which a slave was levied herself. When I was in New Hampshire, Dan Greenwood was teaching property, and when I said, here's a replevin case for you, the replevin tests the right to who has superior possession to the property. Okay, you say I'm a slave. I filed a writ of replevin against you who claims that you're my master, and we'll see who has the right to superior possession to the property. You won the case. And I wasn't doing it as a property case, but that's just an answer to that. The real point is that the cases laid out in that chapter involve a series of parallel fact patterns. Take a look at page 7. We have a guy who annoys a justice of the peace and is tossed from jail. We have someone who's claiming to be wrongly held as a slave, and someone who's claiming that he's imprisoned in violation of a statute forbidding the imprisonment for debt of members of the armed forces. And all of them are released by writs of habeas corpus. Now take a look at pages 8 to 9. And again, we have a guy who annoys a justice of the peace and is tossed into jail. Someone claiming to be wrongly held as a slave. And someone claiming that he is imprisoned in violation of a statute forbidding imprisonment for debt of members of the armed forces. And all of them are released, but not by filing for writs of habeas corpus. As you see, one of them demands and gets a writ of certiorari. One of them, the slave, demands and gets the writ of personal replevin, it's called. And one of them demands no particular writ at all, but winds up getting some mashup of a writ of supersedious and a writ of prohibition. And the question I ask is why we should today make any distinction between the first set of cases, which are habeas corpus cases, and the second, which formally are not, but certainly are in all but name. The distinctions among common law writs, which are not only totally obsolete, but which American colonists screwed up at the time, as historians love to point out. Level of practice in New Hampshire was not quite as it was all. And none of this has any relevance to any question that we are interested in, which is the point of note 54, citing Erie versus Hopkins. Keep following. And they have to cite Erie versus Hopkins. This is a nice little case in which the judge concludes that a debtor is being illegally jailed because the evidence doesn't support a debt high enough to warrant incarceration, and orders the jailer to release it. But he doesn't send a writ of habeas corpus to the jailer. He sends an injunction to the jailer to cease detaining the debtor. So what? As a functional matter, that's a habeas corpus case, regardless of what you call it. And so were all the other ones in which release was granted by certiorari or personal request. All right. And chapter 3 then spins out some of the implications of taking that view. First of all, if what I just said makes sense to you, it should make sense to the Supreme Court. Not necessarily, but it should. And if so, then it follows that in habeas corpus cases, particularly ones turning on historical practice, as opposed to ones involving post-conviction review, which are heavily based on modern statutes. But in the others, everyone should be able to exploit in briefing the full universe of cases involving common law judicial review of imprisonments, even if not called habeas. And that would be a change to current practice, and I think an entirely appropriate change. And that's particularly important in cases like the ones arising in Guantanamo and similar circumstances, because the Supreme Court held in 2008 in a case called Boumediene that irrespective of any statute, the suspension clause protects, at minimum, habeas corpus as it existed at common law. And that's a come on to by the book, because I spin all that out in chapter 15, which I haven't given. But which is here for questions. All right. Second.
Questions at the end.
Yeah, questions at the end. I'll be done soon. Second, regardless of what one called the writ, when a potentially unlawful imprisonment was at issue, the courts took a fact-centered approach that prioritized a speedy and just resolution over grand legal pronouncements. And one could encourage today's district courts to do the same. And here, I line up in parallel two situations on pages 19 to 20. After the glorious revolution that put William and Mary on the throne in 1689, it was far from clear that they were going to be able to retain the throne. James II still had a lot of supporters, particularly Catholics, who were underground in England and very much above ground in Ireland and France, and there was open warfare in Ireland for another 2 years, and much plausible fear of invasion, either from Ireland or from France. And that led to lots of people being picked up as suspected subversives. And Halliday's database of 5,000 cases includes 147 from this period. And as you see, the judges went carefully into the facts and concluded that the government had solid evidence warranting detention in 20% of the cases, and that the other 80% of the prisoners should be released. Now, my suggestion, based in part on statistics in footnote 90, showing that in modern contexts, like the tribunals applying rules of due process that we had after the first Iraq War. In the first Gulf War, you may remember the Iraqi army was surrendering to us in the hundreds of thousands. And of course, most of them, the soldiers just let go, but they detained some of them, and they got status hearings. And the vast majority were released. And that and a similar context show that the government's evidence, leaving aside any legal question, the government's evidence is often questionable, and so the common law focus on facts as opposed to modern emphasis on law makes a lot of sense. And to illustrate that, I compare those William and Mary proceedings to Judge Leon of the U.S. District Court in the District of Columbia on page 20. As you see, when the Guantanamo cases came down to him on remand from the Supreme Court in 2004, after the Supreme Court had held in the Rasul case in 2004 that the writ of habeas corpus extends to Guantanamo statute. He didn't schedule a hearing. Instead, he granted a motion to dismiss. And it took until 2008 and the Supreme Court Boumediene case that I mentioned to get that reversed. And so only in 2008 did he actually look at facts. And when he did, he concluded that as to 5 of the 6 petitioners, there was no there there. And as you can see in footnote 95, he very bluntly told that to the Justice Department lawyers and urged them not to delay the long overdue release of the petitioners by yet another appeal, and said to them, look, I am holding person number 6, and you'll obviously person number 6 will appeal. You can assert all your legal positions on the appeal of that case, and that's exactly what happened. The 6th one, the 5 were released. The 6th one appealed. Justice Button took its legal position, and the appeal succeeded in obtaining a remand. And back in the district court, the case unraveled yet further, and eventually that petitioner was released too. And this is the right approach. I'm happy to debate with Julie the nuances of enemy combatant law, enemy combatant law, and whatever it is you want, right? But it only makes sense to do that in the context of cases where those facts are material. And as you see from the whole section A, starting at the bottom of page 15 and running all the way to page 17, that was the common law approach in addressing challenges to imprisonment of all kinds, regardless of context, whether they were picked up during a rebellion, whether they were slaves, whether they were whatever. And regardless of procedural niceties, whether they sought habeas corpus, which are. And I think that makes sense here. Of course, in some cases, at the end of the day, after the facts have been established, they pose a legal issue. But that should come second rather than first. First, let the government prove its facts to the extent it can. And then, if the judge determines that those facts form a basis for detention, let the prisoner take an appeal on that legal point. But in modern times, we've been doing too much of the opposite. And by we, I mean not just the government trying to establish broad legal principles, but challengers seeking to do the same. You know, that there are broad theories of illegitimacy of whatever the proceeding got us here, rather than focusing on their own cases. And judges who passively address the issues as framed by the party in those macro terms, rather than the common law approach as described at the bottom of 17 and the top of 18, if indeed the case is going to turn on a legal issue, the judge should make the parties agree on a narrow statement of it and then rule on that issue. And by that method, judges in habeas cases would not only be doing what's fair and expeditious, but also in a separation of powers way, playing their appropriate role in the overall system. And you can, when you buy the book, read me saying at page 15 that they're playing their appropriate role, in checks and balances of potentially abused power. But I would be happy to also add during questions that they are playing their appropriate role in a separation of powers way in not legislating but adjudicating. I think at that point I will now stop for questions, comments, whatever.
I will keep the rest, but I want to just ask, can I ask a question first?
Sure, put yourself in top of me.
This is actually just a kind of, I just don't know. Are there any consequences for the government of not being able to make their case, or of, in the Hamdi case where they just ended up letting him go without even coming to a hearing, where they just sort of don't even have any evidence to back it up? Is there civil penalties?
No, because in yet another part of the book, I launch a rather intense attack on doctrines of official immunity, which have spun out of control in recent years, and the citation for all of that comes from a bunch of conservative scholars who write things that say it's incoherent, unprincipled, unfunctional, and that's the modern worsening of what's been some of the long-term trend. But so the answer is no. Not only does it tend not to be any consequences, but and this is another theme, as you'll see from the introduction, another theme of the whole book. The writ of habeas corpus only makes sense as part of a whole structural system, because the writ of habeas corpus works if you are present in the jurisdiction and are challenging the basis of your confinement. It doesn't work if they have spirited you away, if you are challenging like being tortured while in confinement, if all kinds of other, having been sent off to a foreign government to be tortured, all kinds of other challenges that don't fit within the four corners of habeas corpus. And so that's why one of the other main themes of the book is that if you're assessing the strength of the system of rule of law, we all love habeas corpus, but we have to see it in perspective of the whole machinery.
That's really fascinating. Okay, so Barbara, I saw, Julian, I saw you.
Yeah,
Okay,
yeah.
James. Yep. Okay.
Hi, I know nothing about criminal law, criminal procedure, any of it. And so if you could, I need you to back up and explain some things. Now, if I assume you're looking at all these wonderful ancient cases, not just because you are a closet historian, but because now when somebody is arrested, there has to be some kind of paperwork, an arrest warrant or something setting forth a basis for arrest or for locking somebody up and holding them. Is that correct?
Not quite.
Okay. But let me just finish. If we're so related to that is if terrorists are treated as criminals, wouldn't such paperwork follow like the day the night?
If terrorists were treated as criminals, as some of us have been advocating since the day Guantanamo opened, and it only took a few months after Guantanamo opened, because the goddamn thing couldn't get into the journal any faster than that, then yes, it would. And yes, you would have avoided all these problems, and you would be very much farther along than you are now. But that didn't happen, and so here's what did happen when I showed up to give this talk to 300 federal defenders who had come in as cavalry to deal with this mess. I said, all right, I say habeas corpus, and you are thinking of the modern statutory post-conviction writ, which came after the U.S. Civil War. The thing was enacted in 1867 to enforce the 14th Amendment because the southern states were denying people's rights. And so we wrote a very innovative statute that said we can challenge in federal court the our detention on the basis we're being held in violation of the laws or Constitution of the United States under a conviction of a state court. And 99% of all cases since then have been about that. It's governed by an incredibly complex statute. You may know it. It's called EDPA. Part of that statute's about immigration. That's screwed up, but it doesn't begin to deal with the other screwed up part, which is about state prisoners challenging their convictions. Okay, but I said to the 300 federal prisoners, forget all that. That is not what we're talking about. What we are talking about is some guys in the Tower of London, locked up for whatever the hell reason in the Tower. He throws a note in a bottle into the Thames that says, "Help me, I'm locked up in the Tower of London." And a lawyer or a friend or somebody sees that note and takes it to a judge and says, "Judge, I want a writ of habeas corpus so that somebody will tell me what the hell's going on." That's what we're talking about. That had become essentially obsolete in the United States since the Judiciary Act of 1789, and I happen to have Section 14 of the Judiciary Act of 1789 in my briefcase, just for instance. Which
doesn't everybody?
Yeah, but mine has boldface.
Touché.
Which did create a statutory system, and therefore all this common law stuff became irrelevant until the moment, for the first time since 1789, so the moment in the wake of the Rasool decision that that statute extended to Guantanamo, Congress amended it to say, oh no, it doesn't. And people who are being detained as enemy combatants have to go through some administrative procedure in the Defense Department and blah, blah. Okay. Which was challenged as a suspension of the writ of habeas corpus and resulted in a victory in the Boumediene case, which said that does not meet the requirements of common law habeas corpus, and the suspension clause protects the writ as existed at common law. Well, okay, so all of this profound research into what the hell the writ of habeas corpus was at common law was provoked by the sudden need to find out something which no one had any interest in finding out since 1789.
Okay, but the international law argument hadn't been...
The international law argument...
wasn't enemy combatant.
Well, okay, yeah, that, of course, that was all made, and you know that the Hamdan turned part on that, and of course, yes, of course, that was all done, and so that more in Hamdan, we considered whether these were tribunals that met the international standards of fairness and so on. That was not, for one reason or another, the focus of what they did in Boumediene, although, of course, all the same people showed up and filed all the same briefs.
Oh, sorry. Julian.
Okay, I have a bunch of questions, but I'm going to just focus on one. If I understand you, sort of making constitutional originalist argument in this sense is that all this matters is because we're trying to figure out what the suspension clause means, right? And when you can, to some degree, the scope of the suspension clause. And the best way to interpret the suspension clause, the scope of it, is determine what habeas corpus means. And what it means is what you say it means, which seems very convincing to me. Although, doesn't what really matter is what the draft, if you're an originalist, wouldn't what matter be what the drafters of the Constitution, when they drafted the suspension clause, thought they meant by using the word habeas corpus? So isn't your burden then to show that the drafters of the suspension clause agree with you? When they use the word habeas corpus, they actually meant things like replevin as well.
Well, first of all, you're not going to get me to elaborate on nuances of whether originalism means what they really thought, what they would have thought if they had been educated, what the public meaning was. I don't know any of that, but I tell you what I do know, and I do say later on, which is that Bunyan took a very functional view of this, said the purpose is to call the jailer to account and to be able to order release if necessary. So from that, I spin out, citing a whole bunch of law reviews that have said the same thing. Okay, well, if that's the purpose, that's the function, then the court conducting the independent inquiry has to be able to do that, which may mean discovery and stuff which didn't exist at common law. So no, it's a purpose of originalism, right? It's an originalism which is based on the function, but no, it's not tied particularly to the procedural details. I wouldn't say horse and buggy age, but in an age when obviously bringing somebody from here to there was a big deal. So the judges, the poor judges, they would ask questions like, at common law, would it be okay for me to conduct this hearing for a guy in Guantanamo by video? What did George Washington think about nuclear weapons? You can't possibly hire me to answer that question, or at least if you did, nobody would give me a research leave to go answer that, right?
Well,
but you could very rationally say, yes, there are innumerable cases in which the judge thinks it's indispensable to hear from the detainee, including a very famous case in the U.S. Supreme Court called Bowman, which is the subject of a couple more chapters of this thing, which arose out of the Aaron Burr conspiracy. And a couple of the alleged conspirators sought a writ of habeas corpus from the U.S. Supreme Court, and they were sitting there in the U.S. Supreme Court when the bench went line by line through the affidavits said to justify the detention, and said they're insufficient, and the people walked out from under the court. So, I can't tell you anything about video, I can't tell you, but I can tell you that conducting a full and fair inquiry into the circumstances before I make any legal rulings is what we are trying to do, and then whether anybody thought that habeas corpus actually covered writs of certiorari too, I don't know. But we know that. I mean, we know that when and this I guess is an academic addition of mine. I say that the common law responded in a common way when faced with an allegation of unlawful imprisonment, whether the proceeding was brought on a writ of habeas corpus, writ of certiorari, or something else. So that should inform Your Honor's view of what's appropriate for a habeas judge to do.
Okay. James?
So the first question, I have a dozen questions, but I'm going to limit it to two. The first one I think is a nomenclature issue, or maybe my lack of understanding of the process at Guantanamo. So the post-Boumediene process that is, in your framing, common law habeas, that's the CSR hearing or no?
No. That was what was invalidated.
Okay.
No. Now, you guys just have to buy the book. I couldn't lecture 16 chapters of it.
Right.
Now, what they have in theory is common law habeas. Technically what we did was we invalidated the amendment to the Judiciary Act of 1789, so that's gone. So we're now back under the Judiciary Act of 1789, so we have common law habeas. In truth and in fact, due to a whole plethora of rulings by the DC Circuit, which I attack as shameful, disgraceful. They have very much truncated the evidentiary hearings, and people are not getting out, and the statistics that I pointed you to show the difference between when the district judges were conducting full and fair hearings and what happened since. But to answer your conceptual question, yes, we are now at common law habeas, which is a judicial procedure.
Okay. So, and your answer to that actually teases, I think, and maybe this is, I hope this is of interest for everyone, but recognizing it's not possible to do what I'm about to ask you to do. But what is the 2-minute synopsis of the current state of the Union vis-a-vis Guantanamo? Like, what are the big questions that are left for the government and for the defenders as well in terms of what's left vis-a-vis Guantanamo, the big ideological questions?
In 2 minutes. 2 minutes.
In 2 minutes. That's the impossibility. Recognizing, but that's
the next book.
No, the conceptual and legally largest question is, by what authority are you now detaining anybody, bearing in mind that the rationale that prevailed was under the authorization for the use of military force against those persons who were responsible for the attack on 9/11. We construed that to mean, and we can detain under the laws of armed combat, we can detain enemy combatants for the duration of the conflict so they won't go back to the field. And that's okay. So the overarching legal question at this point is, yes, and how does that apply to anybody who you totally legitimately picked up 15 years ago as fighting for the Taliban against the Americans in Afghanistan? Well, you know, there ain't no such, point one. And point two, and everybody on Capitol Hill recognizes this and just hasn't been able to come to a substantive solution. And point two, then more broadly, yes, and what does that have to do with Niger, Syria, any other place where you now are? Right? Considering particularly that most of those groups were rivals and adversaries of the Taliban, tried to, you know, I mean, it makes, nobody thinks that makes any sense. So the overarching questions at this moment are legal.
Yeah, so while you were talking, I took a quick look, and Korematsu refused to relocate. So his was a criminal prosecution.
That's right.
But Mitsui Endo was in a camp and said, I want out. And she sought habeas. Was her habeas statutory habeas or common law habeas?
Oh, she was within the territory of the United States and absolutely governed by the 1789 Act, right? It was not post-conviction. She was in federal custody, and she was bringing under what's now 2241. But that Judiciary Act of 1789 plainly applied to that, and that's what she did. And that's what I told the federal defenders they would be doing. We just had to get the jurisdictional point that being a camp on Guantanamo is the same as being a camp in Hawaii or California or state of Washington. But once we got that point, there's no question that that's where we are. Because what the Judiciary Act of 1789 happens to say, for all of those who have it up, right, is people in the custody of the United States.
I apologize. I don't think we met.
I'm Mike Lampert. I'm an adjunct, and I actually teach in about an hour.
Okay, well,
and Eric and I used to work together many years ago.
At which time, I mean, it's one of these things. Right? We're always together, and I got the academic job. He should have got.
I don't know. Should I ask you? I do have one other question based on your question. As Eric remembers, I used to know the CPLR, and I do remember this provision. If a state court judge doesn't issue a writ, they have to pay $1,000 to the person who sought the writ.
I'm glad you mentioned.
Does anybody else have that?
Yes. Yes, and that it goes back.
To your question.
It goes back to the very first thing I said, which some of you missed, about the difference between habeas corpus as meaning an order that says you shall produce the body. New Jersey has the same statute, and an order meaning release the prisoner. Many states, including New York, including New Jersey, I'm sure including others, have something that says when an application is made to a judge for a writ of habeas corpus, meaning bring me this guy from the Tower of London, tell me what the hell you think you're doing, the judge shall issue it. No ifs, ands, or buts. The judge shall issue it. And if not, pay a $1,000 fine, be removed from the bench, be criminally prosecuted. Right? So, yes, New York has that. And while I was at Paul Weiss, we tried to get a reporter for the New York Times out of jail that way. And successfully, to the extent of getting a writ of habeas corpus issued. Right? Remember Myron Farber?
I do.
Yeah. Okay. So yes, as I said, and that may almost go to the original sentence. The states understand very clearly, right, that ordering the custodian to appear with the detainee and show the cause of detention is in fact the core of the writ.
Do you want to go again? Yep.
Does anyone else?
Were there any other
Oh, yeah.
first bites? Yeah.
I don't have
Do you
that
wanna
much.
introduce yourself
Karen
also?
Fernback, visiting professor, teaching labor and employment law. I don't really know criminal or constitutional that well, but I would be curious to know, what is the status then? How many, I mean, maybe you don't know this, the prisoners right now, are they getting these habeas corpus hearings in Guantanamo? Are the judges going there? How is this working?
I believe that the last number I saw was something like 149, more or less. But all of the people now there have had habeas proceedings, which, because of all kinds of restrictions placed on evidence by the D.C. Circuit, have all been affirmed. So they're now running through the administrative review process that various administrations have set up in various iterations, and some get out that way. But one of the classic rules of habeas corpus is there's no such thing as res judicata. And the Supreme Court has actually written that sentence a couple of times. And you can, there is under modern statutes about state prisoners, but there isn't in common law. You can keep applying, and a judge is supposed to equitably look at all the facts and circumstances. So therefore, there is nothing wrong with, and would be nothing wrong with, some or all of those people returning to the habeas proceeding and raising new legal issues, saying facts have changed, whatever you may have found or been required to find it about whatever it is that I did 20 years ago is irrelevant to the jailer's current right to detain me. And it's a reasonable prediction that you will see something will happen along those lines.
Were these hearings going on in Washington or in Guantanamo? District court judges?
To the extent that some of the district court judges, did take testimony, which they did by video.
Right. I see.
In many cases, there was paper or at an early stage in this, when a district judge ordered the government to bring the prisoner to his courtroom in Washington, that was successfully resisted by the government on the grounds that it would be a violation of separation of powers because it would violate the immigration laws. A theory which, one in the D.C. Circuit, then it makes sense to some people, but some people thought was some people thought otherwise. But anyway, the result of that was that there have been some video hearings.
Video hearings, okay.
So, Julian?
Yeah, I just can't get look, it's an incredible project, and I know that you've been digging around New Hampshire for a while, but I just can't get my head around the idea that habeas corpus is not habeas corpus, which seems to be the burden of this book. That it turns out habeas corpus is not actually habeas corpus, it's actually So when the courts in the past called something habeas corpus, we should treat that as habeas corpus. But then when courts did something else, when they didn't call it habeas corpus, we should treat that as habeas corpus as well. See, that's a pretty heavy burden to convince people that we should. And I guess it's a philosophical point, like just because I mean, this is the most basic formalistic, legalistic thing that we do every day, right? It's category X, right? Category Y. Those cases are persuasive, but not as persuasive as the ones in the other box. Why wouldn't we just why wouldn't the book be habeas corpus is habeas corpus? But also there are these other cases that are functionally similar, which could be persuasive. But it seems like you're going farther and saying, actually, no, they really meant, in some formalistic sense, habeas corpus, but they just didn't use the magic words habeas corpus, so we should treat it as if they did, which is a huge historical burden to lift, right?
Well, I'm sure that when you and I rewrite my thesis, we'll be saying the same thing, right? And it comes in two parts. Part one is, and that's why it's broken in a separate chapter, was knowing habeas corpus when you see it. Things that actually are called habeas corpus, that then come to these rulings that say habeas denied, are being grossly misunderstood. And those are, so that's telling the Supreme Court, it's on the Fourth Circuit, what habeas corpus cases that they're looking at actually mean. So that's squarely within the box. Then the second part of the box is, I say, on an overview, that the common law responded in a uniform set of ways, whether the thing was called habeas or certiorari or supersedious or whatever. And so, yes, here in that chapter, I've got a bunch of habeas corpus cases in which it was done. I've got a bunch of certiorari and supersedious and other cases in which it was done. That should be, yes, persuasive precedent. And so I say, okay, functionally, those are habeas corpus cases too. Like the person did the same procedural thing that the other one did and got out. So in all function, it's the same. And yes, judge, if you want to put things into legal boxes, no, it's not a habeas corpus case, but it sure should give you comfort in, if I say, in a habeas corpus case, you can bring the prisoner in to testify, and I cite you 3 habeas corpus cases in which that happens. And I also cite you 3 supersedious and certiorari cases involving unlawful imprisonment in which that happens. That should give you greater confidence in ruling for me in my habeas case.
I'm sorry, but you're not saying that if there's no such habeas case, that I cite you 3 non-habeas cases, you should do this anyway.
Well, yeah, I would, I would certainly say that, right? I certainly say that. I would certainly say that since the function was the same, nobody was really paying a whole lot of attention whether they issued a injunction to the jailer not to enjoin you from further detaining him, or whether they had sent over something called writ of habeas corpus. I would certainly do my best to persuade you that if the best I've got is the one, not the other, it's precedent, but obviously, it's less direct precedent.
All right, I'm sure Eric will be willing to continue this discussion with anyone who is still interested, but in terms of the formal workshop, let's just really give you a... Yes, and